This account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many, I suspect, who are worried about their immigration situation, but they're not sure if they should speak to an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think that your situation is nearly identical to one of the ones that I go over here, you still need to speak to an immigration attorney personally. Even the smallest factual changes can make a big difference in the outcome. That said, this is not legal advice. I'm hoping this will merely help educate people as to how the immigration laws work, because I know there are a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change quite a bit in the months to come. So what might be accurate and current at the time of this recording very well could change in the weeks to come, maybe even tomorrow. Someone would get a 2-year green card if at the time that the green card is issued, okay, not at the time that they apply, but at the time that the green card's issued, if their marriage to the US citizen is less than 2 years old, okay? So imagine a couple gets married, they file 6 months later, they file for the green card, and it takes 6 months to get that green card, all right? Then the foreign national is going to get a 2-year green card. Now, let's say for some reason they file 6 months after they get married, but USCIS kind of sits on the case for an extended period of time, and they don't get the green card until after 2 years have elapsed. Then they're going to get a 10-year green card, even though they filed at the same time in relation to their marriage. So the reason that this is, and I believe it came about in the 80s, but my understanding, there were all kinds of stories of people marrying US citizens, getting their green card, and then 2 days later going and filing for divorce, shaking hands and being like, thanks, thanks for the favor. So this is kind of a defense against that, is, okay, you just got married and you're applying for a green card. It seems like you are a real couple, so we're going to give you this green card. However, it's conditional. And 2 years after we give you this green card, we want you to file more documentation, show us that you're still living together, you're filing taxes together, maybe you're renting a home together, an apartment, sharing car insurance, sharing health insurance. They want to see that you're doing all the things that we would expect a married couple to do, okay? Maybe you've gone on some trips together and you have some flight itineraries and you've got photos with your families and all that type of stuff. So that's why it's conditional, okay? Yeah, we believe it. We think this is real. However, we want you to check back in with us 2 years later. If you've been married for a longer period of time, when you get the green card, then they give you a 10-year green card because they believe that, okay, you've been together long enough, so we're going to give you the full permanent residency, not the conditional residency. When that 2 years is up, okay, so you got your green card in March of 2024, it expires in March of 2026. The 90 days before expiration, that's your filing window. That's when you need to file your I-751. It's a 4 or 5 page, maybe 7-page form asking your address and where you work and all this other type of stuff. That's the form, but then you need to include evidence with it. And you want to have as much evidence as possible. You want to have leases, you want to have insurance documents are great, car insurance, health insurance, life insurance. Bank accounts are great, car registrations showing both names. I essentially have a list of probably 30 different types of evidence that we can use. I never expect my clients to have all of those things, but I basically tell them, hey, the more we have, the stronger our case. And the thing to keep in mind when it comes to an I-751 is, unlike the green card case where you were always going to get interviewed, it's a requirement that you get interviewed. There have been periods of time where they waived that. But with the I-751, it's completely at the government's discretion on whether they interview. If you include a lot of documentation to show that your marriage is real and that you're still living together, they're probably not going to interview you. But if your evidence is thin and you don't have a whole lot there, then they're probably going to say, you know what, let's call these people in. Let's talk to them about this. So, having a comprehensive filing, the immediate first impression is, wow, that's a lot of documentation on this marriage. That's going to help you avoid an interview. And, which even if it's a real marriage, no one really wants to sit down and get interviewed over their marriage and take the time to meet with an officer for an hour, 2 hours, whatever it might be. So. Your window to file is 90 days before your expiration. So do not file early. You want to file within that 90 days. Don't file late either. That can have all kinds of complications too. So you want to make sure you file within that window. There are some exceptions. If you're filing with your spouse and you're still married and you're still living together and everything's going well, then you file within that window. If you split up with your spouse, if someone filed for divorce, if you've been the victim of domestic violence, so maybe you got married and then you applied for the green card and at some point the relationship became toxic and the US citizen started being abusive, either physically or emotionally, then you can actually file before that 90-day window, okay? You're gonna want evidence of that. Hopefully there's a police report. It's not required that there be a police report, but obviously that adds to the strength of the case if there is abuse. So. Yeah, so when you file your I-751, you're going to get a receipt notice. Hopefully those show up within 2 or 3 weeks of filing. We have had situations where it took much longer, 2 months even. So you want to make sure that when that 90-day window opens up, the goal is to file as soon after the window opens up as possible so that you have your receipt notice before your card expires. Now, when you get that receipt notice, it's going to say that your conditional resident status has been extended for a period of 48 months. Even though your card expires, you have a piece of paper, a government piece of paper receipt that shows that, hey, this has been extended for 48 months. So you are still allowed to work using that. You can still travel, okay? So if you travel outside the United States, you would take your passport, you would take your expired green card, and you would take that receipt that shows that you have a valid 751 that's pending, okay? And it is safe to travel with those 3 things. A lot of our clients are very nervous about that. They say, well, yeah, but my card's expired. Can I get a new card? Yes, you can get a new card. Eventually that will show up, but in the meantime, you can travel using that piece of paper. What I always advise my clients is that, a year after we file that I-751, you are eligible to apply for naturalization. What I've seen in my own practice is that if you file for naturalization, USCIS will schedule you for a naturalization interview, and at that time, they're also going to adjudicate the I-751. And that's the quickest way to get these cases done is by filing for naturalization 1 year after you file for the I-751. I've had clients that say, well, I'm not really interested in naturalizing. I'm okay with being a resident. Okay, fine. That's fine. Maybe you're from a country where there are certain implications of trying to get US citizenship, like Germany, for example. But what I've seen in those situations is that the I-751 will remain pending for a very long time. 2 years, maybe even 3 years. It almost feels like USCIS is saying, okay, we got your I-751, we're going to put it over here. When you naturalize, then we'll take a look at it and we'll start processing it. That's kind of how it feels like they operate to a certain degree. So I always encourage people to file for naturalization as soon as you're eligible to do so. And then we can take care of all this stuff at once and you'll never have to deal with immigration again, basically. Yeah, so hopefully when you filed for the green card initially, you provided some documentation, photos together, a lease agreement, those types of things. They want to see that same type of documentation for the last 2-year period. So anything that happened, any documentation you have from before you getting the green card, you can leave that out. Okay, they just want to see the last 2 years. So, different couples are going to have different things. Maybe you spend a lot of time with each other's families at barbecues and family trips and stuff like that. that's great. Show those photos. This is us with his parents camping. This is us with her parents in Las Vegas, whatever it might be. Photos with family are great because people in fake marriages don't spend time with each other's families. They keep it secret from each other's families. Okay, so you want to show that, look, all the families are in support. Insurance documents are great. Health insurance, auto insurance, joint tax filings, car registrations, lease agreements. There's so many things that you can use. If you don't have a lot of official documentation like bank statements and some of those things, we can get letters from your parents, from her parents, whatever, saying that, yes, we spend time with them. They come over probably once in a month to have dinner with us, that sort of thing. Obviously, if you have kids together, you include the birth certificates of the kids. That's going to be huge. But you can get creative with the documentation. And, when we do an I-751 case, we provide a list of probably 30 different types of evidence. And I say, listen, collect as much of this as you can and get it to me, and then I'll review it and I'll tell you, okay, maybe we need to get some written statements from friends or from employers or, whatever it might be, talking about how they've spent time with you as a couple. Okay, but we generally don't do those types of affidavits unless the other type of documentation is really kind of sparse. So we do that kind of assessment to figure out how strong we are in terms of documents. Most of our filings for I-751s, we want them to be literally over 200 pages, 300 pages of documentation. We want that filing to land with a thud on the desk of whatever officer is going to be adjudicating it, so that they're kind of overwhelmed with how much documentation we're providing. If you and your spouse have separated in that 2-year window, you can still file the I-751. Depending on where you're at in terms of divorce, whether it's been filed, whether you're just contemplating it, whether the divorce has been finalized, depending on where you're at in that process, you're going to have a different way of filing the I-751. There's just too many details to go over in a video like this, but just know that if you have separated and you're not living together and you're either filing for divorce or planning to file for divorce, or the divorce is finalized, you probably need to call an attorney to go over that, because another possibility is that you filed the I-751 jointly with your spouse, but after you filed it, considering that some of these cases take a year or 2 years to get adjudicated, maybe then something fell apart in the relationship and now you've moved out and now someone's threatening to file for divorce and all of that type of stuff. How you handle that situation is really going to be fluid too, in terms of when are you obligated to notify USCIS? How should you notify USCIS? The last thing you want to do is be accused of withholding information, so you need to know what your requirements are and your duties are of notifying them, so you don't get accused of fraud or anything like that. So the short answer is, even if you are in the process of a divorce or you have gotten divorced, you still can file the I-751. You just need to do it the right way, depending on your situation. Filing an I-751 on your own probably isn't the best idea, but if you decided to file on your own, okay, that's fine. If you file on your own and you get called in for an interview, you need to speak to an attorney at that point. It's not a normal thing to be called in for an I-751 interview. So yes, there are situations where I've had clients called in and it had to be a random interview assignment. Okay, so that does happen. I've had that happen to clients that have a child together, and we've provided the birth certificate, and the couple lives together. There's literally no reason why anyone should suspect this. So in those situations, it can be random, but most often I would say that if they're calling you in for an interview, there's a reason they're doing that. So if there's a reason why they're calling you in for an interview, you probably want to talk to an attorney, and consider taking an attorney with you to the interview, so that your statements aren't misrepresented or they don't put words in your mouth or anything like that. Because if your I-751 gets denied, now you're absolutely going to need an attorney, because if they deny an I-751, they're sending you to immigration court. Now you're in front of an immigration judge. Now you've got to, convince that judge why your I-751 should get approved. And obviously that's going to get expensive. Getting representation in immigration court, that's going to cost, 10,000, 15,000, whatever it might be to get that kind of representation. So if you get called in for an interview, you need to see that for what it is. It's a huge red flag. It's potentially a big problem, and you need to stop doing this case on your own at that point. Getting your initial green card and conditional green card approved is great. But I think that it is possible that sometimes clients say, oh, okay, great. And then, 2 years from now, we'll just file this other form and we're good. No, you don't know what kind of notes the USCIS officer put in your file during that initial interview. So I've told clients, especially younger couples who, they get married young, they file for the green card, and everything goes smoothly and we get the green card. I think in some of those cases, the officer is willing to say, okay, you don't have a lot of documentation. You're young, one of you's 20, the other one's 22, so I wouldn't expect that much documentation from you. That being said, I'm also approving your case because I know that 2 years down the line, I get to take another look at this, or at least another officer will get to take another look at this and make sure that you have plenty of documentation. So that can be a blessing and a curse. I mean, if you don't have a lot of documentation, maybe they wouldn't have approved your case for a 10-year card because you don't have that much documentation. But because they know they have another bite at the apple 2 years later, they're going to approve you for now, for that conditional status. But all of that to say that you need to know that just because you got that approved 2 years ago doesn't mean that it's smooth sailing and that they're just going to rubber stamp your I-751. You need, it's more that you're 50% of the way there. You got the conditional green card issued. That's 50% of the fight, but 2 years later, it's a whole nother 50% where they really do want to see a lot of documentation. What have you been up to the last 2 years? And if you don't have a lot to show for the last 2 years, that could be problematic. That could result in getting interviewed. If you get an officer that's really not convinced on this, they could put you into immigration court and just say, you know what? Let's have a judge take a look at this and see what they see. So.